Hi, I am Suman Dash Bhattamishra, Assistant Professor of Law at National Law University, Odisha, Cuttack, and today I am going to discuss the module on kidnapping and abduction in criminal law with you. Let me introduce you to the topic first. Kidnapping and abduction are important offences against the human body, and they have been covered specifically from sections 359 to 374 of the Indian Penal Code. An analysis of these sections along with the relevant case studies has been covered in this module. The objective of this module is threefold. Firstly, to inform students of the elements that constitute the offences of kidnapping and abduction. Secondly, to discuss the relationship between the two offences and the purpose behind having such provisions in the IPC. And thirdly, to discuss important case studies so that they are made aware of important legal developments in this area. To begin with, let us try and have a hold of kidnapping as a specific offence in the Indian Penal Code. Section 359 begins by stating that under the IPC 1860, kidnapping is of two types: kidnapping from India and kidnapping from lawful guardianship. Section 360 defines kidnapping from India and Section 361 defines kidnapping from lawful guardianship. Section 363 is the provision that lays down that imprisonment of either description for a term which may extend to 7 years and fine will be the punishment for committing the offence of kidnapping. Let us try and see what the IPC has to say about kidnapping from India. The section makes kidnapping from the territorial limits of India a punishable offence under the Indian Penal Code. It makes use of the word convey, which literally means to transport, carry or take a person from one place to another. So, the offence of kidnapping under this provision is complete when a person is either carried, taken or transported to a place which is outside the geographical territory of India. Reaching the destination in a foreign country is not relevant for the accomplishment of this offence. So, when we take a look at section 360, which talks about kidnapping from India, it is important for us to understand that the offence is accomplished the minute a person is carried or conveyed from one place which is within the geographical territory of India to outside the geographical territory of India. So, it is also important for us to note that accomplishment of the offence does not happen when the person reaches the foreign country. It is complete the very minute that the person is transported from the territory of India. On similar lines, it is also important to note that when the accused is in the process of conveying a person from the territory of India, but his actions are interjected before he can cross the Indian territory, he may be liable for an attempt to kidnap under section 359, but will not be guilty of actual commission of the offence. So, when a person's actions have been interjected while he is carrying a person from within the territorial limits of India, at that very juncture the attempt to commit the offence happens. However, the actual commission of the offence does not happen at that very end. Absence of consent on the part of victim is also a necessary element of the offence. For deciding the connotation of the term India, it is necessary for us to figure out that section 18 of the Indian Penal Code mentions that the term would mean the territory of India with the exclusion of Jammu and Kashmir. So, section 361 is the section which then talks about the actual offence of kidnapping from lawful guardianship, and it has highlighted various elements of section 361. The offence of kidnapping under this section can be fragmented into some major components, which are first and foremost taking or enticing a minor or a person of unsound mind by another person. The minor should be taken or enticed out of the keeping of a lawful guardian. The guardian's consent must be absent. Now, when we discuss the offence of kidnapping, discussing the offence without discussing the elements of taking and enticing is a difficult thing to do. So, let us have our focus on the elements of kidnapping, the first and foremost element, which is taking or enticing. When we talk about taking, the dictionary meaning of the term is to escort or to cause to go. So, when a person is caused to go or is escorted out of the keeping of a lawful guardian, we can say that taking is said to have been complete. So, it is possible even with the consent of a minor. The reason behind making it possible even without with the consent of the minor is minors are not generally considered to be prudent enough in law to take decisions for their own benefit or for their own welfare. So, like a minor does not have the capacity generally to enter into a contractual agreement with another individual, because his or her consent is said to be immature or incapable of giving a consent, because of the simple reason that the maturity of understanding or rationality is absent in the case of a minor. So, the consent of minor may have been present in a given situation, but the element of taking may have been simultaneously accomplished, and this is what we will try to study in the very famous 60s case of S. Varadarajan versus State of Madras. Now, S. Varadarajan versus State of Madras is a progressive landmark judgment in the area of kidnapping. It is progressive due to many factors, but the most important reason behind lauding this judgment as a progressive one is to look at the judgment from a very new and modern angle rather. So, before we discuss the conclusion that the judges reached in this case, I will acquaint you with the facts of S. Varadarajan versus State of Madras. Now, S. Varadarajan's case is a very interesting case, which reads almost like a story of the 60s, forms the content of many of the movies that were made during that time, and ironically this is also a case of the 60s. So, in this case we have two primal figures who are the fulcrum of the judgment. The case revolves around Savitri, a girl who was a student of BSc second year at the time that the offence was said to have been committed, and her friend or paramour S. Varadarajan. Now, Savitri in this case has been stated to be and acknowledged as a minor, but a minor who was on the threshold of attaining majority. Now, in this case she has a sister and she lives with her father. The sisters along with their parents have been staying in Madras, and it is also a scenario wherein the elder sister and the younger sister are both studying in very flourishing colleges. The elder sister was a student of medicine, and one fine day she caught Savitri speaking to someone over the phone for a very long time. When questioned, she said that she was on friendly terms with their neighbor S. Varadarajan, and that she was talking to Varadarajan, and that she had a liking for S. Varadarajan. Savitri's elder sister communicated the message to her father, who was of course livid, and reprimanded Savitri for her conduct. And it is at this stage that Savitri broke down to tears and admitted before her father that she had a liking and was in friendly terms with their neighbor S. Varadarajan, and that she intended to marry this person. Now, a livid father intended to take Savitri out of the context in which she was, and then sent her to a place which was far away from the place of her residence. So, this is also where her father decides to send her to her uncle's place. K. Natarajan is her uncle, whose house she was sent to, and the idea was that the father thought that the daughter would then get over her infatuation with Varadarajan, but as time would have it, that was never meant to happen. And in this scenario, S. Varadarajan and Savitri story was about to unfold in a more dramatic way than ever. So, when Savitri was at her uncle's place, she made a phone call the very next day and asked Vardarajan to meet her at a particular road in a particular place, and this is where their story unfolds. Vardarajan, on the very next day that she made a call, Vardarajan arrives at the venue where Savitri had asked him to come, and he comes to the venue in a car. Savitri enters the car and asks him to drive. They both go to a friend's place who would then be the witness for their marriage, and from there they head towards the registrar's office. What is also interesting about this case is that they get their marriage registered in the presence of their friends, and before actually entering into the marriage, Savitri along with Vardarajan proceeds to a certain place for purchasing jewelry for the marriage, as well as clothes, saris and other valuables which she would be using for the marriage. And the friends witness the marriage, the registrar's office registers the marriage, and finally Vardarajan and Savitri move ahead together, and they spend some time together. They go to a hotel, and from there they proceed to nearby areas in Tamil Nadu. So, what was important about this case is finally they are apprehended somewhere near Madras, and the police files a case of kidnapping, or rather the father of the girl files a case of kidnapping, presses charges of kidnapping of Savitri from his guardianship, or out of the keeping of his guardianship. So, while the charges have been pressed and the court then considers whether a case of kidnapping has been made out or not, many facts come to surface and a lot of deliberation has taken place in this case by Justice Subbarao, Justice Mudolkar, who were deliberating over whether this case should be a case of kidnapping or should not qualify as a proper case of kidnapping. At this juncture, it would be pertinent to point out that two primary issues surfaced in the case to find out whether this case would amount to a situation of kidnapping or not. The first issue was whether the concerned woman was taken, in this case Savitri was taken out of the keeping of her lawful guardian or not. So, the quotient of taking, was it satisfied or not? Obviously, the other question that was raised in this case was whether the consent of the minor Savitri would qualify as a valid matter of consent or not. Now, the judges initially started with the second question. They said that whether the minor can abandon the custody of her father or not is a different question altogether, and luckily we do not have to dive into that domain right now, because the first and most important thing that needs to be established in this case is whether the element of, or the ingredient of taking was complete or not. This is where the court laid down some very important points which is worthy of discussion. The first point that the court laid down was, in order to constitute taking, what is the level of participation or the nature of participation which is required at the end of the person who is committing the offence or the offender. So, the question was, if at all we have issues in relation to taking, we need to figure out how much of participation was there at the end of Vardarajan. Now, Vardarajan's conduct was in study at this juncture. Savitri in her statements had admitted very candidly that she had the desire to marry Vardarajan and that she intended to marry him, and that is why she had herself willingly accompanied Vardarajan. Now, if we look at the factual matrix, Vardarajan has, according to the court, tried to give shape to the intention of Savitri. He did not form or germinate an intention in his mind and then ask Savitri to walk along with him. Rather, it was a scenario wherein Savitri was willing to do something. She had an intention in her mind, she wanted to marry Vardarajan, and which is why she herself made the phone call to Vardarajan, and Vardarajan willingly complied. So, the court points out, and the words are very potent here, that there is a very important difference between taking an individual and participating in fulfilling the intentions of a person or an individual. So, the court says that when you talk about taking, actual participation is of vital necessity. So, the participation cannot be passive, it has to be active, which means that necessary steps have to be taken from the side of the offender. However, Savitri's case is one where she is the one having the germinated intention. She is the one who wants the offender to, or in this case the accused to, walk along with her in a certain direction, and Vardarajan plays the role of a facilitator. So, the court well-meaningly lays down that for facilitating the intention which is already present in the mind of another person, you cannot say that the element of taking has been complete here. So, accordingly, the court also discusses the matter a bit further. So, while discussing the matter, court lays down that if you look at the conduct of Savitri, it is more than active in nature. So, for instance, she had the intention to marry Vardarajan A, that is one important point to be noted. Secondly, she was the one who makes the call from her uncle's house and asks Vardarajan to come to a particular place or to a particular venue. Vardarajan only plays the role of a facilitator by arriving at the place. Thirdly, she is the one who gets into the car, and she is the one who accompanies Vardarajan to the registrar's office to accomplish her intention of getting married to Vardarajan. So, she has even purchased jewellery, saris, etc. for the purpose of marriage, and her participation in the entire factual matrix has been more than active. So, if you look at the participation of Vardarajan in this case, his role is reduced to that of a facilitator, not that of a kidnapper. It cannot be heightened to that of a kidnapper for the simple reason that the element of taking cannot be present here. When you talk about taking, we say that you cause the person to go. Now, there is no reason to cause the person to go, because the cause was already present in the form of an intention in the mind of Savitri. So, the court then discusses the point of taking a bit further and says that the social and cultural context in which Savitri was raised and in which she was brought up has to be taken into consideration. Most importantly, Savitri was an individual who was educated, who was not an illiterate person. She was completely aware of the nature and consequences of the acts that she was indulging in, and was free to take decisions as per her choice, as per her options. The independence that she had acquired was primarily because of the social cultural background from which she hailed. And most importantly, it is to be noted that Savitri's conduct is implicative of or implies the maturity of her mind. So, when you say that a person has committed the offence of kidnapping, we should also look at the intention of the person concerned. Here, Vardarajan definitely did intend to facilitate the intention which was there in the mind of Savitri, but he was not the reason for Savitri to form that intention in her mind and to leave the guardianship of her father. Most important point which was highlighted by the court was that Savitri was not a small child, she was not a school going kid, she was an educated person, and she was at the threshold of attaining her majority. And going by the technical qualifications of calling an individual a minor, in the current factual matrix, it would not be proper to point out that Vardarajan had committed the offence of kidnapping. So, in this case and in the era that it was decided, Vardarajan was acquitted of the offence of kidnapping. He was given a clean sheet in the offence in the charges that were pressed against him, for the simple reason that he was the facilitator and did not really take the minor out of the keeping of her lawful guardianship. So, while the case was decided, there were some important and interesting facts that have come up in this case, which I discussed with you as well. But what you also need to note in this case is Vardarajan's age or his background, who Vardarajan is, has never been disclosed in the case. So, that has never been really discussed in the case. So, Vardarajan remains to us that mystic identity, and he owes his identity in this case to the fact that he was the neighbor of Savitri. So, the progressive judgment that Vardarajan was is also a very important point of discussion for us when we identify the offence of kidnapping by establishing the element of taking in it. Now, the three important points therefore that I would like to recapitulate before we move to other case studies is first and foremost, a passive participation will not make the offender guilty of taking. Active participation is a necessary ingredient. Secondly, you cannot convict a person of kidnapping when the idea or the role played by the person is only that of a facilitator, and especially in the case of a minor who is on the border of attaining majority or is at the threshold of attaining majority. And yes, taking of concrete steps is a very necessary factor. What is also important to be noticed in taking is that actual physical force is not a necessary element. Making the mind malleable is also sufficient for accomplishing the element of taking as required in the offence of kidnapping. So, along with Vardarajan's case, it will only be pertinent to discuss the classic case of R versus Prince, which was very famous for many reasons, but it involved a person called Prince who was charged with the kidnapping of a 14-year-old girl called Annie Phillips. Now, the biggest and the most controversial element in this case was Annie Phillips, as the court has also accepted, never really looked like she was 14 years old. She looked like an individual who was way beyond 16 years of age, and the most interesting turning point of the case was Prince decided to take her out when Annie Phillips misrepresented before him that she was actually 18 years old. Now, when we look at the factual matrix of this case, 2 points have to be noted. One, Annie Phillips, as has been accepted in the court, does not look anywhere to be close to 14 years of age. She looks to be much older than 16 years of age, and secondly, that she has misrepresented her age as 18 before Prince, following which he has taken Annie Phillips. Now, the case revolved around the tripod of taking, consent and reasonable mistake of fact. So, the question here was, can you hold Prince responsible for the commission of the offence under the specific legislation? The problem with Prince's case was Prince did commit a reasonable mistake of fact, and that was accepted by most of the judges in the court. In this background, it was necessary for us to focus on the mens rea of the concerned individual, and the debate was whether we can actually hold Prince responsible for committing the said offence, especially when Annie Phillips misrepresents before him as saying that it's actually something where she qualifies as an 18-year-old and Prince mistakes her to be an 18-year-old individual. Now, the court was divided in its opinion, and the dissenting opinion was equally forcible, was equally kind of acceptable to many. So, while the majority held Prince responsible for the commission of the offence, the question was whether he should be held responsible or not, and the dissenting opinion in this case is noteworthy. Here, the judges who dissented with the idea that he should not be held guilty, their opinion was primarily based on one question: whether Prince can be convicted because he really did not have a mens rea to commit the offence. So, if mens rea is absent in a given case, can you hold a person responsible for the commission of the offence? Now, it is at this juncture that the liaisoning between taking, consent, the diametrics which develop here between reasonable mistake of fact have to be taken into consideration. So, although the dissenting opinion was that the mistake was a reasonable one and therefore, Prince should not be guilty of committing the offence, it was also noted that the offence that he was charged with was one of strict liability and therefore, mens rea did not really have a purpose, but it does send across a very important question. Without mens rea, can we really hold a person responsible for the commission of an offence? So, with this, let us just move to the next important ingredient of kidnapping, which is out of the keeping of lawful guardian. So, what does the term essentially mean is the question. When we say lawful guardian, we refer to somebody who has been charged with the care and protection of the minor, and when the care and protection of the minor as well as the custody of the minor is with the lawful guardian, a person is said to have taken the minor out of the keeping of the lawful guardian if he or she has taken such person out of the control of the person when the minor was had been placed in control of such guardian. Moving on, we need to then figure out an analogous offence and the ingredients of that offence under section 362. Kidnapping is often read together with abduction. Section 362 defines abduction and points out that there are two essential elements, namely compelling an individual by force or inducing by any deceitful means and thereby causing such person to go from any place. So, the offence of abduction is complete the minute you compel the person to move from one place to another place. Abduction is not an offence per se, but it becomes punishable when it is done with an intention to commit another offence. Abduction is an offence if it is done with the intention to commit murder, wrongful restraint or wrongful confinement, so on and so forth. So, the term deceitful here suggests that the means and methods by which a person has been caused to go are actually means which have been acquired by a process of misrepresentation. Now, there are very significant differences between kidnapping and abduction. In kidnapping, the offence is committed against a minor only, but abduction can be committed against anybody. So, whether the person is a major, an adult or a minor does not really make a difference. Secondly, a minor's consent is not relevant for exonerating the accused from liability for kidnapping. Now, in case of abduction, however, the victim's consent will negate liability. Thirdly, kidnapping is committed when a person is taken out of the keeping of a lawful guardian. However, for the offence of abduction to be committed, any person may be moved from one place to another by use of deceitful means or by use of misrepresentation or by the use of force, and only then the offence of abduction will be said to have been committed. So, as we already discussed, abduction is read together with other offences and becomes an offence only when we combine abduction with other offences like murder, wrongful restraint, etc. So, section 363A talks about kidnapping or maiming a minor for the purpose of begging. That is again another form of kidnapping, and also abduction when you send the person out of one place to another. Section 364 makes abduction or kidnapping for the purpose of committing murder a punishable offence. Section 364 penalizes kidnapping for the purpose of ransom with death or imprisonment and fine. Section 365 prescribes punishment for up to 7 years for the offence of kidnapping or abduction. Section 366 deals with the offence of kidnapping, abducting or inducing a woman to compel her marriage and prescribes an imprisonment for a duration of 10 years and fine. The imprisonment may be of either description, may be rigorous or may be simple for that matter. Section 366A prescribes punishment for procuring a girl below 18 years of age with the knowledge that she will be either forced or seduced to illicit intercourse. Section 366B penalizes import of a girl from a foreign country with imprisonment extending up to 10 years and fine. Section 367 makes it an offence to kidnap or abduct a person with the object of subjecting him or her to grievous hurt, slavery, etc. Section 368 penalizes a person who wrongfully confines or conceals a person who has been already kidnapped or abducted. Section 369 penalizes kidnapping or abducting a child below 10 years of age with the purpose of taking some movable property from the person. Section 370 to 374 penalize buying or disposing of any person as slave, habitual dealing in slaves, etc. So, as to summarize what we just covered, it is important for us to take note of a few points that we have already discussed. First and foremost, kidnapping under the Indian Penal Code is of two types: kidnapping from India and kidnapping from lawful guardianship. The definition of kidnapping from India has been provided under section 360, whereas section 361 defines kidnapping from lawful guardianship. Thirdly, there is a difference between taking and enticing. While taking signifies that a person has been escorted or has been caused to go, enticing means that a minor was caused to go or a person was caused to go by showing a temptation of some sort. This significant difference between taking and enticing has always to be kept in mind when we discuss the elements of kidnapping. When we entice somebody, we always show a temptation. So, for instance, A can be said to be taken by B if A just escorts A. So, if the minor is just escorted by the offender, that would amount to a situation of taking. But suppose the offender gives a chocolate to the minor and asks the minor to follow him, and the minor follows him because the temptation was sufficient to cause the minor to move, then that would amount to a situation of enticing. The case of Varadarajan versus State of Madras is a very important case which we have also discussed at length in a very detailed manner, and it is a landmark case and discusses in an in-depth way what constitutes or connotes the term taking. In the case of R versus Prince, the relevance of intention and the value of minor's consent was discussed. Section 362 defines abduction and states that elements of deceit, inducement, force and moving a person away from the place are necessary to establish the offence. There are vital differences between kidnapping and abduction, which we have already discussed, and sections 363A to 369 deal with aggravated forms of kidnapping or abduction. Sections 370 to 373 deal with slavery and forced labor. So, as to conclude, the 5th Law Commission has in its 42nd report suggested various amendments to the definitions of kidnapping and abduction to meet its ultimate purpose of protecting the interest of minor and protecting minors from being kidnapped or from being abducted or from being transported from the territory of India into a foreign territory. That would be all. Thank you.